And today I'm going to be taking 3 bait fishermen out and teaching them the basic philosophies and methodologies of the greatest sport, pastime, and religion in the world.
Clickbaiting.
Like you, be strong to hold the powers of the sun.
It is the world that has been pulled over your eyes to blind you from the truth. I show you how deep the rabbit hole goes. All I'm offering is the truth, nothing more.
Let's listen to Pavarotti.
Can I be your superhero?
Hello, welcome to The Revealing. I'm your host, Pavarotti, and I'm here to discuss the Idaho 4 case. And this is video 2. I put out part 1 yesterday. I was going to put this out last night. As I was working on it, though, I began to peruse other videos related to the Idaho 4 case, and I was astonished, frankly astonished at what I'm seeing out there. Now, it's been going on for a couple of days with this clickbait and 911 call audio stuff, and clickbaiting, Olivia Gonzalez's text messages as if that's some type of evidence in the case. And as I'm watching all this clickbaiting by everybody, I'm sitting back and I'm just a little bit puzzled at everybody's reactions. And then I start to think, what's going on here? Because we all know that the 911 audio hasn't been released via FOIA. So only 2 things are possible with that being the case. One, the 911 call isn't real, which I don't know if it is or not. But number 2, if it is real, how is it released to the 2 biggest guilters on YouTube, and why? And why now? See, those are things that I contemplate. Not is it real? It's what's going on right now that would cause these people to get that. And it becomes quite apparent to me, if the conversation around all of the new information that has been released in this case starts to go in the direction that it was starting to go, meaning we were focusing on the facts and starting to get traction of the truth in this case, well, then what would some savvy individuals who don't want the truth out there, what would they do? Well, they would try to monopolize the conversation, release like a leaked 911 audio to the 2 biggest guilters on YouTube and allow them to clickbait and gain your attention, because without it, nobody was watching their material. In fact, I went through one of their comments last night after they clickbaited their 911 call, and it was funny. One of the comments was that creator saying average view time 3 minutes, shaking my head. And I thought to myself, yeah, that's the only way you're getting that kind of attention there, guy, is if you clickbait. And as soon as they see the clickbait and see your information, they no longer have any value of what you're actually saying. I'm not boasting, but I know what view time means, and I'm willing to put mine up with anybody out there. Put mine up against anybody out there's view time. And view time, what that means is when somebody starts watching your video, what percentage of people are still watching your video halfway and all the way through. And it's always been strange to me. I've never thought about it before. I've seen that stat in my YouTube statistics, but I mean, mine's always 60%. So I guess 40% of the people drop off, after about 2 minutes, maybe not even that long, but the other 60% watch it all the way through. So I know who's watching my videos and how long they're actually paying attention to them. And it lets me know that I'm, doing what I need to do in this case. But when I start seeing this type of thing happen, and then, the Olivia Gonzalez text messages, as if those are some type of evidence. And then now I see people on the other side wanting to jump on the clickbaiting bandwagon, taking the little snippet of the 911 call they have, and then sending people to their channel to get them to gain more viewers. So what was the point of releasing the 911 call to those guilt and clickbaiters? Well, I think we're seeing it play out in real time. So who would be the real culprit? I don't know, but I got a couple of ideas. If it even, in fact, is real. If it's not real, those guys are going to look pretty dang dumb. But if it is real, well, then, there's only a few people that would have released it to them, and that list is very small and very distinguished, I assure you. But it's having the effect that it's having. And then, I listened to one, and this is what frustrates me, because we've gone over this information so many times, showed what was actually said in the hearing, and I hear somebody last night in one of their clickbaits literally go through and say that the judge, when he was talking about Bethany seeing somebody take their clothes off and put it in a trash bag, she literally said the judge was citing case law from a case called Davis. And that's what he was mentioning, that wasn't true because she's seen Olivia Gonzalez's text. And then she went on to say, and people who thinks otherwise, the public school system. I was like, oh, really? Oh, really? Okay. All right. Well, maybe the private school system you attended didn't have any accountability. I don't know, because here's what the judge said, had nothing to do with citing a case called Davis, and it is absolutely relative to this case, and you shouldn't be, if you're not trying to mislead people, you shouldn't be, interjecting your opinion where it doesn't belong because it's not an informed opinion. Listen to this.
That could explain that, including the use of covering clothing and covering gloves and all that could be put into a bag real quick on the way out, that was in one of the affidavits, when there are other things in the affidavit that were affidavits at that point.
Now, maybe I need to have my hearing checked, but did anybody hear him cite a case called Davis? I don't think so. I believe he said affidavits, or the affidavits at that point. Now, when he says affidavits, he's not citing case law. He's talking about affidavits from witnesses. He's citing Bethany's affidavit at that point. So anyway, the clickbaiters, it draws them to their channel and it draws them away from the truth, because the people on the other side of this thing, they absolutely will do anything to draw your attention away from the truth and draw it to the guilters. And then the other side just clickbaits right along with the guilters, plays right into it, and then even points to the guilters and says, go look at their channel. I'm like, come on. They're having a field day. This thing was going in the right direction, and they just interjected some stuff to shake up the entire community with BS. So here's what you got to do, folks. I'm just here trying to get the truth out as much as I can about what's truly going on in this case. And you'll be able to identify clickbaiters really easily that'll draw your attention away from the truth. Clickbaiters will go to old information from 2 years ago and they'll start interjecting, the frat boys did it. Jack D did it. Even the ride share, all right, the ride share guy. I know his name came up in a text, and I knew all the clickbaiters would jump on that and go at it. There's absolutely no evidence pointing any kind of wrongdoing towards the ride share guy. Give me a break. And that being said, the vehicle that leaves out at Linda Lane at 423 is not the same vehicle that returns to Linda Lane at 6:30. More misinformation. That wasn't Dylan going and getting in that car at 423, I assure you. That was a guy that had just got out of the car. Oh, y'all seen it. Nobody wants to show him leaving the car. They just show him returning to it. He gets out of the car and he racks his gun and then heads towards the King Road residence at 350. That ain't Dylan. That is a real person racking their gun, going to do some real things. So the BS out there and the clickbaiting, it's all doing what it's designed to do. Draw everybody's attention away from the facts that have just been released in this case, and the facts that are about to even more be released in this case when all the replies hit. Because today is the deadline for the replies on those motions in limine. So now we get to hear the other side's response to the motions in limine. So more information is about to come out, and they don't want you focused on it. So anyway, I've got to finish this video for you, and then I've got one other to do that covers all those docs that come out, and then I will be right on schedule when the motions in limine replies all hit. So this is part 2. In this one, we're talking about the state's experts and the ridiculousness of the effort the state is intending to put into the trial, focusing on the DNA on the knife sheath, 13 experts. The defense, all they have to do, like I already told you in the video yesterday, stipulate to the DNA on the knife sheath. Now, why would they do that? Picture this. They've already seen the trial, right? They already see the outline of the trial because of the state's experts. If the state spent 2 weeks bringing DNA experts on to talk about that was Bryan Kohberger's DNA on the knife sheath, whether it is or isn't, they're going to bring 13 experts to try to do it over a 2-week period. And the defense sits there and tries to fight that for 2 weeks and tries to delegitimize that. Guess what this trial would have become? If you believe that it's Bryan Kohberger's DNA on the knife sheath from the 13 DNA experts the state provides, well, then you must believe that Kohberger's guilty of the crime. Now, if you believe the defense that they manipulated the evidence and it's not his DNA, well, then you would find him not guilty. What do you think they're going to do? They're going to believe the 13 DNA experts. All the focus would have been on if it's his DNA, then he must be guilty. And then that would be the focus of the trial. Well, it would be pretty dumb for the defense to go in with that strategy and guarantee a conviction. So what do? They go, no, that's okay. We'll stipulate that it's Bryan's DNA on the knife sheath, and then we're going to focus in on indirect transfer and the fact that Bryan wasn't at the house at that time. These more mainstream morons that come out and say, well, they're going to try to say his knife sheath was planted and they planted his DNA. That is absolutely not what the defense is going to present. They're going to present that they have no idea how that knife sheath got there. There is suspicious circumstances around it, but regardless of how it got there, nobody was trying to plant and set up Bryan Kohberger. They're going with the truth, that knife sheath maybe at some point was in the vicinity of Bryan Kohberger and got his indirect transfer DNA on it. That is going to be the defense. And by going that route, they can actually get the jury to focus in on all of the other relevant facts in the case and not just focus in on, is it his DNA on the knife sheath? It is a brilliant move and a strategical one, I assure you. And why is it important at this stage of the game, y'all? People get this so confused, and it's easy to get confused. because this stage of the game is past the motions to suppress. The defense fought tooth and nail trying to get the evidence suppressed. They were not successful. So past that stage now, they're going to trial. They know they're going to trial. We're at the motions in limine to exclude evidence. What they're doing in this last stage is trying to get the things excluded that they need to be excluded so that they know what's going to be going on in this trial. Then after this, there may be a few more motions, but not many. And then they will do their trial preparation based on what's going to be allowed and what isn't. They already know that they lost the battle on the IGG. So to continue to try to fight the IGG at trial would be futile, and it would put the jury's focus on the wrong things in the trial. What they want to do is put the jury's focus on the right things. And like I mentioned in my pie chart yesterday, the prosecution, they're experts. They're only going to have one expert talking about his location data, one expert talking about vehicle identification, one expert talking about crime scene recreation. And what the defense is doing right now is trying to limit those experts to what they can say. And that's what we're about to get into, is this document that is very eye-opening, I assure you. So without further ado, let's get right into it. Okay, so this is motion in limine number 2, vague and undisclosed expert testimony. And hereby, the Bryan Kohberger and his attorneys hereby moves the court for an order excluding vague and undisclosed expert testimony. And then they go into the argument. But Mr. Kohberger hereby incorporates all arguments and authorities contained in his accompanying motion to preclude the death penalty and adopt other necessary procedures due to the state's numerous disclosure violations. That's the one that I went through with you that talks about the confidential informants and the co-defendant in the case that everybody else out there ignores for some reason. Now, the first one is Mr. Kohberger requests exclusion or at the very least limitation of the following expert testimony. And this is Jenny Ayers, forensic scientist. Testimony must be limited to only her work depicted in the Idaho State Police Forensic Laboratory Report number 25 and her checklist of testing in Mr. Kohberger's apartment and office. She has not authored any laboratory reports expressing opinion. So what this is designed to do is just focus her testimony on what she did, not give any opinion that she may have outside the work that she did. Very simple. We're going to come back to Special Agent Nicholas Balance because this one actually relates to the other motion in limine that I have not gone over yet. Those two go hand in hand. So we're going to go right here to S3 and S4. Mr. and Mrs. Barnhart. Testimony must exclude everything other than specifically disclosed, including purported habit evidence. The state has not produced a report specifying what habits are referred to. No expert opinion has been disclosed. Now, this one was kind of weird to me, y'all, because there's no expert opinion disclosed. They're wanting to testify to habits. And when have you ever seen experts that were titled Mr. and Mrs. Barnhart? I mean, does that sound like a husband and wife expert team? It was kind of weird to me. So I scoured the internet for relevance to a Mr. and Mrs. Barnhart. And although I may be incorrect on this, I don't believe I am, but it did take me, a lot of effort to try to locate who these people are. After going through a lot of different stuff, I finally came across this magazine way back in March of April of 1996, and it's the National Parks magazine of the National Parks and Conservation Association. And it talks about all the national parks around, and this is a 60-page magazine. So I took this and I searched Barnhart. And what do you know? Trustees for the parks. Trustees for the parks are dedicated members of the NPCA who, by their annual general contribution of $1,000 or more, continue to ensure thoughtful stewardship of our national park system. We gratefully acknowledge these individuals and their recent support of the NPCA's park production programs. And I come across right here, Mr. and Mrs. Robert G. Barnhart. So, Mr. and Mrs. Barnhart, trustees for the parks. That lets me know that Mr. and Mrs. Barnhart's testimony on habits has something to do with, I imagine, Kohberger's trip to Wawawe Park. Then we have the status review for West Slope cutthroat trout in the United States, September of 1999. And they go over the Portland, Oregon, and Denver, Colorado region, which would include Kootenai River, Spokane River, let's see, lower Missouri drainage, Montana, Idaho, Washington, and Oregon. So when I look up Barnhart in this one, I got R.A., Robert A. Barnhart, Wadowski RS 1977. So he's been around for a long time, and I'm fairly certain this is going to be who they're calling as an expert. So that may end up being important or it may not, but I definitely wanted to know who they were and what they would likely be testifying to. Then we got Mr. Cox, Amazon. Testimony must be excluded because no opinion or full analysis of the data has been provided. It appears Mr. Cox has the credentials to gather data at Amazon, but nothing disclosed indicates he has the expertise to form an opinion on data. And if he does have an opinion based on analysis, neither the analysis or opinion has been disclosed. The full amount of raw data received from Amazon has never been disclosed. Only narrow dates with some purchases have been disclosed, despite warrants seeking very broad materials over the span of a year. And according to the warrant returns produced, excellent Excel spreadsheets, apparently relied on by the state, have redacted purchases without explanation. Context for purchases at least 6 months prior to what has been provided are critical for drawing opinions. There is no full disclosure or analysis of clickstream history that spans the scope of multiple warrants and subpoenas. There is no full Amazon advertising history, AI-driven recommendations, or cookies disclosed or analyzed. The identification of the devices used is not disclosed or analyzed. No cart wish list disclosed or analyzed. No omni-channel tracking data or platforms are disclosed and analyzed for a household where multiple members use the same Amazon account. The search warrant request account-wide data, including linked accounts and evidence and device identifiers for a year span. Now let's take a look at this real quick for just a second. And it says Excel spreadsheets apparently relied on by the state have redacted purchases without explanation. So what does that mean? And the full amount of raw data received from Amazon has never been disclosed. So some data from Amazon has never been disclosed to the defense, and Excel spreadsheets with redacted purchases are disclosed to the defense. Now, redacted not so you and I can't see, but redacted so the defense can't see. Now, how could the prosecution redact purchases from the defense and say you can't see these? Is it because those are Bryan Kohberger's purchases? No, because they would have to give them unredacted purchases Bryan Kohberger made, because that would be evidence they're going to use against Bryan Kohberger at trial. So what does that tell me? The prosecution would not redact purchases made by Bryan from the defense unless it wasn't Bryan that had made the purchases. There is no doubt in Pavarotti's mind that means that they have Kopaka purchasing a K-bar off of Amazon. That's the only reason to redact that purchase from the defense. So Mr. Cox here is basically, as it relates to Bryan, just going to be testifying on a bunch of click activity. The state has produced a select portion of the whole record, cherry-picked. The state has cherry-picked the information. He cannot determine if the state is asserting a direct search or review of items algorithmically suggested through Amazon's ad system. So this testimony must be prohibited. So Mr. Cox here is just going to testify on some cherry-picked search and click information. And if that's not enough to, convince the jury, they're going to bring in specialist number 2, Special Agent Michael Douglas. Not the actor, I'm guessing, but the FBI agent. Any opinion and testimony must be excluded. All arguments set forth in Shane Cox in paragraph 4 above. Oh, Shane there. Are incorporated for Michael Douglas as it relates to any testimony about Amazon and Amazon clicks. The state intends to use Agent Douglas as an Amazon expert without any explanation other than what a cherry-picked group of records might show. The state has produced some records and reports relating to documents collected by this witness. Not all raw data has been disclosed. No explanation of underlying raw data or how it was analyzed has been disclosed. The state has not produced a summary of an opinion about the purported meaning of such documents. So they have basically are doubling up on experts talking about Amazon click activity. Does that make you really confident that they have Bryan Kohberger purchasing a K-bar knife off Amazon? Give me a break. They would have one guy saying, here's the receipt for his purchase. They don't have it, folks. They're cherry-picking click data. All right, next we got S15 to S25. These are all of those lab personnel testifying to the DNA on the knife sheath. Various Idaho State Laboratory expert witnesses are anticipated in trial. To the extent their opinions are limited to the reports authored by them and based on their own expert evaluation is not the subject of this motion in limine. This motion seeks an order preventing testimony outside of their reports. Testimony through any of these witnesses other than their own opinions stated in Idaho State Police Forensic Laboratory reports must be prohibited. So they want them to come in, talk about their reports that they did, and don't give opinions outside of the reports that they did. That is very fair, and that will make the trial fair. Then we've got Rylene Nolan, which I've gone over this one with you. That was a total separate one to actually exclude her testimony altogether and limit her to not say the words touch or contact DNA. And they pointed out in there where she can't be trusted anyways because they got her to lie in the hearing in front of everybody. Then we've got Eric Seat. The expert opinion of this DNA technician, this one is very interesting, y'all, provides an explanation of the possible testimony regarding a methodology for DNA testing, YSTR. Now, none of the DNA samples in this case that we know of was tested using YSTR. The DNA on the knife sheath was just a regular STR profile. The DNA under the fingernails, as far as we know, those were just STR profiles. So why is this different type of profile, this YSTR, being testified to by Eric Seat? What makes it different than all the other DNAs? For which the defense has no discovery or indication that the method has been used in this case, as we just talked about. There's no opinion disclosed other than because of the large volume of discovery, the state directs the defense to summary reports of the expert's ultimate conclusions, which can be found in Lab Report 3. Lab Report 3, Bates number, blah, 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 is DNA data of an alternate suspect. but no ultimate opinion or result is specified. I wonder why that is the case. So, testimony through this witness, other than relating to an alternate perpetrator, must be prohibited pursuant to Idaho Criminal Rule 16, Idaho Rules of Evidence, the court scheduling order, and Mr. Kohberger's federal and constitutional rights to a fair trial, confrontation, and due process. So, my notes on this, first of all, is no YSTR sample exists for any of the DNA in the King Road residence, including Q1.1. No other profile was ever entered into CODIS. So this profile would have been compared to profiles from the sources inside the house. So basically, this is the guy you can bet where they went and got his cigarette and performed a YSTR DNA test on the DNA on that cigarette, created a profile. They did not enter it into CODIS, we now know, because according to them, if they enter one into CODIS, it gets rid of the one they already had in there off the knife sheath. So what did they do with this profile? They just simply tried to match it to other DNA at the crime scene. To be specific, the DNA on the knife sheath, I'm sure, is the only one they tried to match it to. So they didn't put it in CODIS, tried to match it to the DNA on the knife sheath, and it didn't match. So in their minds, this is an excluded individual. Why didn't they try to match it to the blood on the handrail? The blood in the glove, the fingernail scrapings under Maddie's fingernails, or did they, and it did match one of them? There is no doubt the DNA from the cigarette of the alternate, this is the DNA from the cigarette of the alternate suspect. Now the question is this Kopaka or an unindicted co-conspirator mentioned in the Schaefer case, T. Farley? That is a question that I am really waiting for the answer to. This is all BS. I'm not going to go through this whole thing because this is expert opinions related to the 67 electronic devices and third-party data collected during the investigation. This is Maury, Agent Tanzola, and Agent Urig going through all these devices, and they're going to try to show basically what I showed you the other day. Based on the devices and the purchases, Kohberger was here when the victims were here. He was here when they were here. And then the other thing they're going to do is go through and show all of his search history on Google and other things over years and years and try to paint Kohberger as a depraved individual because of his studies as a criminology student for 8 years. These three yahoos are going to testify on search history and websites that BK visited, no doubt for school research as a criminology student. And God forbid, like any 28-year-old man, he probably looked at a few of those dirty sites, and that will paint him as deviant. Just ask Steve G., like he said in his interview. Now we're going to skip that one for now and go down to this one right here. This is David Middleman. This expert was disclosed as a rebuttal expert relating to IGG matters. This expert is addressed in a separate motion in limine number 12. So they agreed that he would not be called as an expert because the defense said they're not going to call Hellwig and Larkin as experts, and he was going to be a rebuttal expert to rebut their testimony. So he is off the list. So that leaves us with Gary Dawson right here. Now, this expert was disclosed for the first time in the state's rebuttal experts. He is a toxicology expert. Mr. Kohberger did not disclose an expert relating to toxicology. This expert is not a rebuttal expert and should be excluded from the trial. So what they're saying is if he is a rebuttal expert to rebut a toxicology report, the defense did not put forth a toxicology expert for him to rebut. So he needs to be removed. But what does that tell us? That is huge right there, folks. If the defense is not going to bring up toxicology of the victims, then that tells us that the defense's strategy as it relates to drugs is not going to be that the King Road house was a drug house, or else they would absolutely want to focus in on the victim's toxicology reports, wouldn't they? No, they're going to focus on the fact that the victims are not using, they're not bad people. It was the sins of their parents that caused this atrocity, not the sins of the victims. And that is the absolute proof to that right there. Now we're going to go to this one right here. Now this is another rebuttal witness. Now they may have they may have an expert that I have not identified yet that will also testify to crime scene recreation, but I think this one right here is very interesting, Mr. Detective Gilbertson. And the state did not disclose Detective Gilbertson in their initial disclosures, but instead listed him as a rebuttal witness. Now, in my mind, you would think the state would put a lot of effort into the crime scene recreation, but if this is what they've got as a rebuttal witness, and they maybe have one other state expert that's doing the crime scene recreation that I haven't identified yet, that should tell you everything you need to know on where the state's focus at trial is going to be. And it's not on actual evidence and facts, but on painting a picture that is that could be painted on any one of us. The state did not identify any specific expert or opinion that the detective will rebut this. Thus, the court should exclude this testimony as outside the scope of rebuttal and irrelevant. Moreover, the court should exclude testimony under 403B. The relevance of this testimony is minimal at best and carries a serious risk of juror confusion. Now, this is where it gets interesting. The detective walked alone through a house that he is intimately familiar with in the middle of broad daylight more than 1 week after the house had been vacated and changed significantly due to an unaliving investigation. He simply counted out loud upon entering rooms. That means he's walking into the house and going 1, 2, 3, 4, 5, and he's walking upstairs 6, 7, 8, 9, 10, walking into the room, counting out loud as he estimates the time it took to unalive people, then counting out loud, walking downstairs to the other room, and then counting out loud as he walks out of the house. Now that is going to be their crime scene recreation? Are you kidding me? This is a far cry from what the state alleges occurred. Additionally, Mr. Kohberger attempted to learn more about the experiment that the guy was conducting through discovery. He sought things such as recordings and photographs of the timed run. So that means he timed driving the vehicle around, walking into the house, or written notes taken and documented during the experiment. Nothing was provided in discovery. Nothing was provided in discovery. The prosecution stated those items did not exist. Now, I've got to ask you folks, if this guy conducts an experiment, give me a clean spot here to draw on. So he conducts an experiment. He does a timed drive, pulling into the King Road neighborhood, coming around Linda Lane Apartments, parking behind the King Road residence, getting out, walking to the house, walking in, counting as he goes upstairs, counting as he comes back downstairs and goes into the other room, counting as he leaves that room and goes back out and walks back to his car, and then timing his car from driving there to where it would be seen on the 1112 King Road camera. And then nothing is provided to the defense as related to that experiment, and the prosecution states those items don't exist. What does that tell you? That tells you the experiment that he conducted proves that there is no way Kohberger could have done what he did in the time frame that they're saying he did it in. Bam, bam. Even their crime scene rebuttal detective is in my humble opinion, aware that Bryan Kohberger couldn't have done this crime. And my notes on this were, are you kidding me? The state's only crime scene expert is a rebuttal witness. Now, they may have another one. The state will not put an expert on to testify to the crime scene situation. This is why we're so gung-ho to tear the house down. Yeah, after this experiment that he did, what do you think the prosecution did at that point? They said, call Scott Green, have his buddy Larry Germer get his construction company together and his main excavation operator, T. Farley, and get over there and tear that house down and go bury it in Wasankari Construction so nobody can find it, because if not, we're in big trouble. That's exactly what happened. So now I ask you, where do you think people like Steve G and the prosecution and law enforcement would like your attention right now? Do you think it's on the facts that's come out in this case, like I just showed you right there, that they did an experiment timing everything, and upon completing that experiment, destroyed all of the evidence of the experiment? The prosecution says it doesn't exist, and then promptly tore the house down? Do you think they want you to know that? Do you think they want you focusing in on the defense's motion to preclude the death penalty, where they bring up the confidential informants and the co-defendant? Do you think they want you focused on that? Or do you think they would rather have you focus on 10 seconds of a 911 call that shows the roommates in distress as they make the call, not even thinking it through? I mean, think about it for a second. If you've heard that distressed 911 call, well, then you have to really stop and ask yourself, what are they so distressed about? If you listen to that 911 leaked BS call, then the roommates are so upset as they're dialing 911, you would think they had seen 4 people unalive. But as you go through the call, you clearly know that they haven't gone up and looked at anything. And everybody out there that thinks the door was closed and they had to force it open hasn't read the court doc, where it says when the detective went through there with his body cam, every door in the house was open, including that one. If you listen to the 911 call, nobody went up and pushed the door open and seen an unconscious person. But regardless if they did or not, until they pushed the door open and seen an unconscious person, they wouldn't have known that those people were unconsciously unalived with a knife. So why are they making the 911 call in such distress if they didn't know that? I mean, what they knew at that point, according to them, is nothing different than what they knew when they woke up at 10 a.m. and started texting and calling people. So you're telling me that from 10 a.m. until the time people got there, they were in a hysterical state? So when they dialed 911 to ask about an unconscious person, it was just a continued hysterical state from 10 and it's noon? Give me a freaking break. If they hadn't already seen what was taking place, that 911 call should have been calm, not hysterical. It should have been, hey, we got a roommate up there we think is unconscious, and there was a guy in the house last night. We don't know what's going on. We need some help out here. Not, oh my God, oh, it's terrible, what's wrong? We don't know, but we haven't known for 8 hours now, so I don't know why I'm crying. Give me a break. Use your freaking heads, folks. Put your thinking caps on. Come on. Please like and subscribe to this channel. Post your comments, your thoughts, your criticisms, and until next time, Pavarotti's out.
Oh, gonna give it a shot. Only one of me to shield you all from the enemy.